Hello, my name is Ribellia, and I'm presenting on behalf of the plaintiff who is a patient of Ashford Hospital. I will be playing a juror. HIPAA stands for the Health Insurance Portability and Accountability Act. This act was passed and enacted by Congress in 1996. HIPAA provides the ability to transfer and continue health care insurance coverage for millions of Americans and their families across the United States. This act can also help reduce healthcare fraud and abuse by protecting patients' information. This law mandates industries to set standards for healthcare information on electronic billing and other processes such as a patient's electronic health record, or EHR. Under HIPAA, anything remotely relating to the care and treatment of a patient requires the utmost protection and confidentiality when handling protected health information, or PHI. Additionally, the HIPAA privacy regulations require healthcare providers, healthcare institutions, as well as third-party associates to continuously develop new and innovative ways for their employees to follow procedures that ensure the confidentiality and security of protected health information, whether it is transferred or received internally or externally, handled or shared across any entity in the United States. This applies to all forms of PHI, including paper, oral, or electronic. Furthermore, only the minimum health information necessary to conduct business is used or shared. The plaintiff is a patient at Ashford Hospital, and she is scheduled to undergo surgery. However, that schedule was distributed by electronic means to an unauthorized person, her supervisor. That email contained her name, social security number, date of birth, reason for her surgery, current medications, and her past medical history. All of this is sensitive information. Even though her supervisor did not personally gain anything from the information that was shared, but then again, it is against HIPAA to disclose information to any persons without prior consent from the patient or client or the employee. Protected regulation of the HIPAA privacy rule is the minimum necessary requirement. This rule is based on that protected health information should not be used or disclosed when it is not necessary. The minimum necessary standard requires all individuals, organizations, and healthcare institutions to assess their practices and enhance further safeguards needed to limit unnecessary or unauthorized access to protected health information. The rule of minimum necessary requirements are designed to be sufficiently flexible to accommodate the various circumstances of any covered entity. Furthermore, covered entities such as healthcare providers must make every effort to limit their use or disclosure of PHI. It is up to the covered entity rather than the patient to determine what minimum necessary means. Also, there are some situations where the minimum necessary standard is not applied, such as information disclosed that is connected to a treatment, or when a patient authorizes disclosure of information. Ashford Hospital is in violation of this law, since they sent a copy of the operating room schedule and the patient's information to the supervisor without having prior consent to disclose the information by the patient. The minimum necessary standard was not used in this matter because the information that was shared was connected to the surgical treatment for the patient, and Ashford Hospital had no right to share the information with the supervisor because it sounds as if the patient's job did not require her to disclose her treatment. Furthermore, I agree with the plaintiff's position that the information shared with the plaintiff's supervisor was beyond the scope of the supervisor. Depending on the job of the plaintiff, the supervisor may require that some health information should be disclosed, such as medications, family medical history, or details about the employee's lifestyle, such as smoking. But the supervisor can only have the information the employee had volunteered to give and can receive no further information from any source without prior consent from the patient. Just because a person has shared information once does not give an institution or employer the right to gain access to protected health information without prior consent from the patient or employee. Consent should have been obtained from the patient in written form, and it sounds that Ashford Hospital had failed to obtain consent from the plaintiff before sharing her health information. In conclusion, I feel as if the plaintiff was wrong and Ashford Hospital was in violation of the law due to the fact that no consent was granted by the patient prior to dissemination of sensitive data. Thank you for your time, and I hope my fellow jurors feel the same as I do.